Okay, I see that we are ready to go. Good afternoon, everyone. Thanks everyone for joining. My name is Hannah Bruinsma. I'm from Love Palestine, and it's an honor to moderate today's panel. Welcome to everyone joining on Zoom, and especially the Jurists for Palestine Forum and those following live. This event has English and Arabic interpretation, and for those listening in Arabic, my colleague Nuran will start with a few words.
Thank you هانا. مرحبا لأعزائي المتابعين باللغة العربية. هذه الندوة سوف تكون باللغة الإنجليزية. هناك ترجمة فورية إلى اللغة العربية. يمكنكم الاستماع للترجمة العربية من خلال النقر على الأيقونة على شكل الكرة الأرضية أسفل شاشة الزوم واختيار اللغة العربية. في فقرة الأسئلة والتعليقات يمكنكم طرح أسئلتكم وتعليقاتكم باللغة العربية وسوف يقوم المترجمون بترجمتها. للمتابعين عبر يوتيوب سوف تستمعون للندوة فقط بالإنجليزية. سوف يتوفر تسجيل الندوة مع الترجمة الفورية باللغة العربية على موقع منظمة القانون من أجل فلسطين مع نهاية الأسبوع. شكرا. Back to you, Hannah.
Thank you, Nuran. So today's discussion is organized with our partners, the International Centre for Justice for Palestinians, PCHR and Al-Haq. We're deeply grateful for their support in making this conversation today possible. And we're very lucky to have today a panel of amazing speakers. First of all, we have Basel Al-Sourani from the Palestinian Centre for Human Rights, Dania Al-Haq from the International Centre for Justice for Palestinians. We have Shane Darcy from the Irish Centre of Human Rights of University of Galway, and Natacha Bracq from the Hind Rajab Foundation. Our focus today is on individual criminal liability for serious international crimes in occupied Palestinian territory. The questions that we will discuss today are: how can strategic litigation be used to bring army commanders, state officials, and corporate leaders who profit from occupation, land grabbing, and all other serious crimes before court? And which pathways exist in national and international level? And what are the legal and political consequences of pursuing these cases? Individual criminal liability goes beyond the government and companies to the decision makers themselves. This means that you're holding the people who are actually responsible accountable. And this is based on the principle that no one is above the law. No generals, no ministers, no CEOs. After almost 3 years of the ongoing genocide, and more recently the intensified assault on Gaza City by the Israeli occupation forces, the question is not if, but who should be prosecuted for these grave crimes. Article 146 of the Fourth Geneva Convention obliges states to search for and prosecute anyone who has committed grave breaches of the Convention. These grave breaches include acts such as torture, war crimes, and crimes against humanity. This reflects the principle that these crimes are so grave that they harm the whole entire community, international community. And therefore, states have an obligation to act and prosecute. And this is very important because we should not see this as an act of charity, but really as an obligation by states to prosecute these grave breaches. Under universal jurisdiction, states can prosecute these offenses regardless of where they are committed or the nationality of the person involved. Even crimes committed abroad by non-nationals can be tried. This is possible when a state has passed the necessary laws to apply international law in its own courts, which will also be covered by the speakers. An example of what happened recently, for example, is that the Belgian Federal Police arrested 2 Israelis this summer at the Tomorrowland Festival after complaint by the Hind Rajab Foundation and Clan. And this is a signal by Belgium's readiness to act on its obligation to prosecute. But where civil society is stepping up for accountability, we also see strong forces trying to block these efforts, to stop these organizations and to stop public prosecutors seeking justice. This means that we find ourselves in a world where the US has placed sanctions against judges and prosecutors of the International Criminal Court, undermining the independence of this leading international judicial institution. This also means that we find ourselves in a world where leading Palestinian human rights organizations, including Al-Haq, Al-Mazan, and PCHR, were put by the US on a sanction list because of their ICC-related activities. These are a direct attack on the global human rights movement. It's an attempt to stop states to engage with the ICC and to hold individuals accountable for the gravest crimes committed against Palestinians, including war crimes, genocide, crimes against humanity, and the crime of aggression. And this makes the work and the research of the speakers here present today even more important. Our speakers today will share more about individual criminal liability in national and international courts. Together, we will explore concrete strategies for using strategic litigation to demand justice for Palestine. During the session, you're welcome to participate by sharing questions in the chat, and in the end, during the Q&A, and we have enough time to ask questions, to answer these questions. So please feel free to share your questions in the chat. I would like to now welcome our first speaker, Basel Al-Sourani, he's an International Advocacy and Relations Officer at the Palestinian Centre of Human Rights, PCHR. Basel, you have 10 minutes. Please take the floor.
Thank you very much, Hannah, and for the invitation. And it's a pleasure to be alongside the great list of panelists that are in this webinar, and for highlighting this important topic, which comes after 23 months of genocide, of war crimes, crimes against humanity, of starvation, of forced displacement at a time when Palestinians are at a high risk of being ethnically cleansed from the Gaza Strip and moved outside their territory. Let me start by saying, as PCHR, we've been active not only since the genocide began, but we have experience in terms of universal jurisdiction before even Palestine joined the Rome Statute of the ICC. And we've tried that for many times to hold Israeli leaders accountable, including Tzipi Livni and Doron El-Moog, for example, in Britain. And we've been, and unfortunately, our attempts, due to some political interferences, have failed in bringing those leaders accountable, not only in Britain, but also in other countries. And since Palestine joined the Rome Statute, we've put a lot of effort, along with other Palestinian human rights organizations, to pursue justice for Palestinians in that avenue. And we put we invested a lot of time, a lot of work. And, unfortunately, the arrest warrants, they came against Netanyahu, but they came after almost 1 year of genocide, not prior to the genocide. Although we've made before that submissions on many different crimes that have happened in the occupied Palestinian territory, including on Operation Protective Edge in 2014, on the Great March of Return protests, on the siege of Gaza, on the illegal settlement, on the pillage of natural resources. And we've engaged with the court on all its stages, and we got the arrest warrants, which is by itself a huge achievement in terms of breaking the impunity. It's the first time that we see an international justice body issuing an arrest warrant for an Israeli leader. This is unprecedented. Unfortunately, it came after tens of thousands of Palestinians in the Gaza Strip lost their lives. The entire Gaza Strip has been destroyed after starving the Palestinian population in Gaza. But nevertheless, it marked an important step in pursuing justice. We know that Israel is a powerful state that is an ally of the United States. And as we know, when we think of litigation, we think of using international law. When we think of pursuing accountability, this means, yes, there is law, but there's also a lot of politics that are involved in the back stage. of things. But nevertheless, as Palestinian human rights organization, as someone coming from a human rights organization in the Gaza Strip, we never lost belief. We've always, despite everything that's happening, despite the live stream genocide, the numerous crimes that Palestinians have experienced, and lastly, it's the genocide that's happening for 2 years. We never lost belief because international law, it's not only about Palestine. It's about not only about Palestinian victims, but about victims everywhere. And we've paid, I think, for our work with the recent the shameful US sanctions targeted the political sanctions that have the first time ever we see we see human rights organizations being sanctioned, not because they have done nothing, but because all their work is in accordance with international law. It's because all the evidence they have provided to the international bodies is solid and holds and those responsible accountable for its clear-cut evidence. And it's not only really our work which has done this. We come as part of the genocide that has happened against the Palestinian people. So you were speaking about the risks, the political and legal consequences of pursuing these cases. Right now, our organizations, they are almost paralyzed, not paralyzed, but the aim is to paralyze us, to isolate us from the rest of the international community, to dry up our resources, to have our bank accounts closed, to install fear in those people who work for these organizations. We've done nothing wrong. All we've done was in accordance with international law, with the international law that the U.S. Claims and human rights that the U.S. claims to uphold, that Europe claims to uphold, and unfortunately, that's the consequence we are now facing for pursuing accountability for our people, for advocating for the rights of the Palestinian people. Nevertheless, we want to take this opportunity to stress that we will continue with our mission, regardless of the names, regardless of whether it's Palestinian Centre for Human Rights, it's Al-Haq, or any other entity. We will continue with our work, and we will continue pursuing this work because we believe that the wall of impunity has been broken, and it's a time for all of us, those organizations that are involved in this field, to put all their investment into this. We see Israel cracking. And if it wasn't for that they are feeling the heat of this important work, which we sometimes, we doubt whether it will be productive or not. But if this step tells us anything, it tells us that they are feeling the heat. They are feeling that they're, the accountability wall, the accountability clock has started. And we will continue with this path all along. We have also, beside our work with the International Criminal Court, our constant engagement until this very second with the court, and for the coming months ahead, we even in the last few weeks submitted, along with Hind Rajab. Sorry for this. We submitted with Hind Rajab the targeting and killing of Anas al-Sharif and other journalists. We worked on this together and made an submission to the Office of the Prosecutor of the International Criminal Court. We've also made a recent submission also with the Hind Rajab concerning the targeting of Nasser Hospital, which resulted in the killing of several journalists, health workers, including paramedics and other civilians in that incident. So we're still continuing with that regard. But in terms of even using the national courts, in European courts specifically, We have cases along with our partners, FIDH and other Palestinian human rights organizations against the Dutch government in the Netherlands for their complicity in the ongoing genocide and to try to impose an arms embargo on the Dutch government. Unfortunately, the court in the first instance, it stood with the narrative of the Dutch government that it's on a case-by-case basis, that's how the exports for licenses are granted. But we have appealed this decision just recently on the 3rd of September. We're also engaged with the FIDH, International Federation for Human Rights, in individual soldiers, especially against the ghost unit of the Israeli army, going after some of its members in European countries, in France specifically, and Belgium and Italy. Of course, this work, it wouldn't have done without the support of other partners, of other dedicated people who are really needed in order to carry this. At the end of the day, we have limited resources and we need to depend on other legitimate, credible organizations and people who believe in Palestinian rights, who are not scared of taking this step, because this is a moment where it's shown, especially with the three designated Palestinian human rights organizations, who is really standing with the rights of the Palestinian people, who's willing to take the risk to hold those Israeli leaders responsible for the genocide in Gaza. I just want to conclude by saying that it's important also to ensure that our work continues, that the EU activates its blocking statute. The EU, we are partners with today, the EU Commissioner for Human Rights. She stated that she's alarmed by these yesterday, she stated that she's alarmed by these designations, and that we play a critical role in informing the EU on the violations that are happening in the occupied territory. But today it's an important time. If really the EU cares about those organizations who have been working in this field for dozens of years, to enforce the blocking statute to protect them from the US sanctions, which have a grave impact on the work that we are currently conducting, on our operations, on our documentation, etc. Thank you very much.
Thank you, Basel, and thanks so much for sharing all these insights and showing us what keystones already happened, but what still needs to be done in this important moment. I would like to now go to the second speaker, which is Dania Abu Al-Haj, who's a senior legal officer at the International Centre for Palestinians, which is also a partner for this event. She had led legal work on the business of human rights, torture and ill treatment cases, administrative detention and defamation campaigns against Palestinian NGOs. And Dania holds an LLM from University of Edinburgh and LLB at Al-Haq University. Dania, please take the floor.
Thank you, Hannah, and thank you for organizing this panel. I think it's going to be very useful. And it was very insightful to hear from Basel around the recent updates. I think I was asked to mainly speak about ICJP's work in litigation when it comes to the West Bank. And that's because we've touched in a different seminar about our litigation when it comes to Gaza. So I'm going to be taking it from where Basel, or some points that Basel has touched upon, which mainly is the recent submissions that they have made regarding the targeting of journalists. And I think this draws back into some piece of work that we've done in 2022, where a coalition made of ICJP, Byman's, Doughty, Street Chambers, the International Federation of Journalists, and the Palestinian Syndicate of Journalists submitted 2 Article 15 communications to the ICC regarding Israel's long-standing and deliberate targeting of Palestinian journalists. The first communication was actually on behalf of the families of Ahmed Abu Hussein and Yasser Murtaja, who were Palestinian journalists who were killed by Israeli forces while covering the Great March of Return, protests in Gaza in 2018, and Mu'adh Amarna and Nidal Shtaya, who were left severely injured after being shot in the eye by Israeli snipers, again, also while covering demonstrations against the Israeli occupation. All 4 journalists were wearing clearly marked press vests when they were shot. And I think at that point, when that submission was made, yes, there was a long-standing policy of deliberately targeting journalists, but nowhere near as apparent and as clear as it is today. The second communication that was submitted at that point was regarding the killing of Shireen Abu Akleh, the shooting of Ali Samoudi and Shada Hanaisha by Israeli forces in Jenin refugee camp on the 11th of May, 2022. So this, I think, draws onto the fact that there was a lot of work happening before international legal bodies and a lot of submissions to the ICC specifically regarding a set of different crimes. And in this case, we're talking about the deliberate targeting of Palestinian journalists. And, where everyone is relieved that the arrest warrants did finally happen, though a little bit too late for systematic crimes that were being committed against Palestinians for decades. Now, what I'm going to be touching upon is more of the litigation that we are currently undertaking in the UK. And I think on that, I'm going to focus mostly on corporate accountability or complicity, as we call it. And on that, I'll be touching upon 2 pieces of litigation. One would be our civil claim against British Petroleum, and the other one would be our sanction submissions against the World Zionist Organization. And these are really relevant in today's developments, specifically considering the deteriorating situation in the West Bank, the increasing threats of annexation and land grabs and settlement expansion. And, in light of taking the opportunity that all the focus is mainly on Gaza and what's happening there. So I think it was very important, and specifically in light of the latest advisory opinion that was issued by the International Court of Justice. So I'll start with the claim against British Petroleum, and that is a legal claim that highlights BP as as a key supplier of oil to Israel via the BTC pipeline, and the pipeline being a critical infrastructure component for oil transportation, and which is majority owned and operated by BP. So it's a civil claim, and basically we're making the case or the allegation that BP's actions breach its stated commitments to human rights under international law. This claim is happening before a British court, and the laws that we're referring to are mainly the UN Guiding Principles on Business and Human Rights, prohibition of complicity in war crimes and crimes against humanity under customary international law, and obligations under the company's own human rights policy, which requires BP to avoid contributing to human rights abuses. And in that claim, we obviously reference the ICJ's ruling in 2024, or the advisory opinion, which acknowledged the real and imminent risk of genocide in Gaza. So that is an attempt to litigate against corporations that are currently, complicit in crimes happening in Gaza. And our lead claimants on the case are actual Gazans, Palestinians who are in Gaza, who have suffered real harm, and have provided us with witness statements, and we're currently acting on their behalf. I think the other case I'll be touching upon is the World Zionist Organization case. So in June of this year, we've submitted a comprehensive recommendation for sanctions against WZO Settlement Division, including also a recommendation for sanctions against a senior individual within the organization. And we targeted the WZO Settlement Division for sanctions because it is the most prolific funder of illegal Israeli settlements in the West Bank. In our recommendation, we argued that in order for UK sanctions to be effective, they must target influential financial actors rather than just individuals. And the WZO settlements division's activities include allocating private Palestinian lands to settlers without the owner's consent, managing land without oversight or requiring compensation, and neglecting to collect debts on loans provided to settlers, and playing a key role in establishing illegal settler outposts. This sanction submission builds upon ICJP's previous charity commission work, where we had identified a number of charities in the UK that were transmitting funds into Israeli organizations that were committing illegal activities. And we had filed a number of different formal complaints with the Charity Commission against these charities, claiming that they were fundraising for the Israeli military, promoting hate speech, for example, and demanding an investigation into the matter, as they were violating their regulatory status or obligations. And on that a bit, I'm just going to clarify what the sanctions or the global human rights sanctions regime is, or regulation. And basically in the UK, this sanctions regime basically imposes financial, director disqualification, and immigration sanctions in order to deter and provide accountability for activities which, if carried out on behalf of a state, would amount to a serious violation of a certain set of rights of an individual's, mainly the right to life, the right not to be subjected to torture or cruel, inhumane, and degrading treatment, and the right to be free from slavery and not to be held in servitude. So I think these are the main things that I wanted to cover in today's, brief discussion. There's a lot of other work that we undertake when it comes to corporate accountability, and that includes work that is undertaken against universities that are complicit in either investing in illegal Israeli settlements or investing in arms manufacturers. Also, other corporations and companies that are doing the same thing and making a profit off of Israeli illegal settlements and the pillage of Palestinian natural resources in the UK. And we believe that that's a very important streamline of work to be done, specifically in the UK, to be able to actually use the legal norms that we have, the Proceeds of Crime Act in the UK, which we are highly relying on, and to force UK courts to make these companies abide by their own obligations via the law. So this is what I'll be touching upon today, and thank you.
Thank you so much, Dania. Now I'd like to go to the third speaker, which is Shane Darcy, who is the Deputy Director of the Irish Centre of Human Rights at the School of Law at the University of Galway. And Shane will also have 10 minutes to speak. Thank you.
Thank you, Hannah, and thanks to the organisers and the organisations for the invitation to participate alongside those who are really at the front lines in the pursuit of accountability and justice in the context of Palestine, and some, as Basel pointed out, who've been attacked and sanctioned for their work. I was asked to speak on the topic of individual criminal responsibility in the context of accountability for international crimes, with a focus on complicity in Palestine and the role of the International Criminal Court framework and its relevance for domestic prosecutions, something which Dania has already referred to. The first thing I would say is that efforts at corporate accountability have to focus at the domestic level, not exclusively, but certainly in the main. Because if we look at the lifetime of international criminal law, and we can say it is now around 80 years old, we've struggled to find any successful prosecutions of corporate leaders before international tribunals. The post-Second World War cases that we often refer to, such as the Zyklon B case, were before military tribunals or of one or other of the Allied powers. The only time that we've seen a company being addressed before an international tribunal, before the Special Tribunal for Lebanon, it was for offences against the administration of justice. Now, this is not for the lack of effort. This is not a mere oversight. France, as many of you will be aware, did seek to include legal persons, which would include companies, within the jurisdiction of the International Criminal Court back in 1998 when the statute was being drafted. But that was unsuccessful at that time. That being said, there's been no concerted state-led effort since that time to amend the Rome Statute to include corporate criminal liability. And while individuals can obviously come within the court's jurisdiction, the lack of a specific provision on corporate liability, I think, has reduced the impetus to focus on corporate complicity. And that has a knock-on effect on focusing on corporate leaders. So despite civil society petitioning the prosecutor of the International Criminal Court in relation to various instances of business involvement in international crimes, Australia's offshore detention, for example, weapon sales by European countries to others involved in various conflicts, we have not seen any such cases being brought forward. We can explain this in various ways. I think prosecutors at the ICC are risk averse. They have a limited budget. They're highly selective and at times take a political approach. They would also say that they're focused on those who bear the greatest responsibility for crimes in situations before the court. And despite some early language about following the money, corporate leaders have not featured amongst the several dozen indictees, and in some cases those prosecuted at the International Criminal Court. Of course, that's not to say there's no such thing as corporate involvement in international crimes. I think that's abundantly clear to all of us here. Special Rapporteur Francesca Albanese's most recent report on economy of genocide clearly highlights the range, the nature, the variety of ways in which companies can be involved in international crimes. But for a court that can only focus on natural persons, like the ICC, there may be fewer single individual corporate officers or directors who might be said to be at the same level of culpability as political or military leaders. One example that did come to mind was Yevgeny Prigozhin, who was the former head of Wagner, who was present in Ukraine, who was accused of involvement in breaches of humanitarian law, but he was killed by Russia, and therefore he won't appear ever before the International Criminal Court. But within the field of business and human rights, the focus does tend to be on complicity, on a sort of more indirect involvement in international crimes. Aiding and abetting gets a specific mention in the UN Guiding Principles on Business and Human Rights. So it may be true that the majority of corporate involvement is indirect, but it's not always the case. I think that needs to be borne in mind. But it is one of the reasons why the focus on the domestic sphere is critical, given what I mentioned already about the International Criminal Court. And we see this national orientation for corporate accountability recognized in the draft Business and Human Rights Treaty, which creates an obligation, not yet in force though, but certainly in ways you can say there's parts of it already part of the state's human rights obligations, is that states should adopt measures at the domestic level for corporate accountability, including civil, administrative, or criminal as appropriate and as depending on a state's domestic legal system. Now, of course, domestic legal systems are not without obstacles, and there are many of those, and the colleagues here today will be well aware of them and may speak to some of them, but they do offer more opportunities for legal action than the International Criminal Court itself might do. Even though it has a higher profile, even though it might get more attention, in practical terms, it's less likely that someone is going to succeed with one of these types of cases at the ICC. That being said, the Rome Statute is not irrelevant for pursuing accountability of this nature, and neither should it be seen as a sort of a limiting instrument. So first of all, it gives us our widely agreed enumeration of international crimes, including those of relevance to Gaza and Palestine more broadly. So the war crime of starvation, crimes against humanity of persecution or apartheid, and of course the crime of genocide. So in some instances, we have the statute, the elements of crimes, or indeed case law that gives sort of an authoritative interpretation of the meaning and scope of these offences. We can also look to other areas of international criminal law for that. But the Rome Statute is not complete. It doesn't include all international crimes Collective punishment is not in the statute. The crime of ecocide is proposed, but not yet in there. Scholasticide, which is discussed in increasing terms as a potential international crime, is not in the statute, but yet what we've seen in Gaza and unfolding more and more in the West Bank is a concerted effort to destroy higher level education in Palestine. So the statute is relevant, but it's not a limit either. But national authorities are expected to have legislation in place that gives effect to the statute. So you may find many national jurisdictions that have transposed the crimes of the Rome Statute into their domestic laws, sometimes with some changes, sometimes with some additions, sometimes with some distinct differences. And the same we might say about modes of liability. So the ICC talks about things like aiding and abetting, co-perpetration, etc., which are relevant for corporate cases and demonstrate that this is an acceptable form of criminal liability. And we may see some of that translated into domestic law. But sometimes they don't, and they rely on their own previously existing modes of liability in their own domestic laws. Now, we don't have any complicity cases at the ICC. So we haven't had a clear judicial pronouncement on aiding and abetting just yet at the court, but we've seen it elsewhere. But again, domestic courts might take different approaches. So in terms of prosecuting corporate leaders at the domestic level, we certainly have domestic precedents, previous and ongoing cases dealing with business people, the Van Anrat case, the Kuenhoven case in the Netherlands concerning supply of materials, supply of weapons, and the London Energy case in Sweden, where you have 2 individuals on trial for aiding and abetting war crimes in Sudan. So these cases draw on international criminal law concepts and crimes, but they have a firm basis in domestic law. There have also been cases against individuals who we wouldn't classify as leaders. So the controversial Blackwater prosecutions in the United States relating to the Nazur massacre killings in Baghdad. Nazur Square killings in Baghdad, I should say. So here we see even lower level individuals can be prosecuted. A few of the things that need to be borne in mind in relation to cases like this is, well, what is the route to commencing a case? Is a complaint sufficient? Is there a prosecutor or indeed a politician, such as a Minister of Justice, who must authorize cases, including those under universal jurisdiction? Or might victims have direct access to courts, comparable to civil litigation? Do organizations need to think about working with the police, with prosecutors, with politicians to educate them, to inform, to socialize the idea of such prosecutions? And also then the value of taking cases, even if they're never going to get to court. The important symbolism or deterrent or indeed knock-on effect of such cases. The Rewal case in the Netherlands, and maybe PCHR were involved. I know Al-Haq, where the company's premises were raided, the company was in the news, they withdrew from their operations in the West Bank because of the negative publicity that they got in that instance. Now, they weren't properly held to account. I think that needs to be borne in mind, but there was an impact. And finally, just a little kind of note to mention that we do have a significant issue here in using criminal law. It tends to be very, very individualized, very, very focused on individual victims, perhaps, but certainly on an individual perpetrator. When we're looking at corporate involvement in international crimes, it's really a massive structural issue. And again, Francesca's report really demonstrates the way there's such a significant involvement in the genocide. But criminal law is not necessarily always suited to that. So we have a square peg of systemic contributions to international crimes, but then we have the round hole of individual criminal liability. And trying to identify specific individuals who bear such responsibility is a challenge. But no doubt there are candidates. We speak of the Gaza Humanitarian Fund, we speak of the arms manufacturers. There is definitely scope for pursuing these sorts of cases. Non-criminal processes, like the South African Truth and Reconciliation Commission, is far better at explaining and understanding the various ways in which companies were involved in the apartheid, But that's after the fact. That's a different matter. And that's not to say it's not irrelevant, but for our current purposes, it's a different undertaking. So that was just a couple of broad comments that I wanted to make at the end, and to reiterate the relevance of the International Criminal Court and its statute, but also the significant limitations of using that institution itself in this context. Thank you for your time.
Thank you, Shane, for outlining these concepts so clearly to us and giving us all these examples. I would like to now move to our last speaker, which is Natacha Bracq from the Hind Rajab Foundation, who's the head of litigation there. Natacha, please take the floor.
Thank you very much, Hannah. Good evening, everyone. So today I'll be talking about the Hind Rajab Foundation work and how in our work we mix offensive and strategic litigation. I'd like to really emphasize on the different strategy that the foundation has taken over the last few months. And so when the foundation was founded less than a year ago, in September 2024, a small group of volunteer lawyers and activists shared this single conviction that the national and international courts must become the arena where Israeli soldiers are accountable for the crimes, international crimes, war crimes, crimes against humanity, and genocide in Palestine, and that the wall of impunity that has been put in place for far, far too long must be pierced. And so we have built this two-pronged approach, mixing offensive litigation, which is the rapid tactical strike against perpetrators, with the strategic litigation, which is more of a longer-term strategy. And so rather than treating them like separate chapters, we have intertwined them together, and this is those strategies that drive our mission. So I'd like to first address the offensive litigation, because this is what most people know us for. And so offensive litigation is what we call the legal guerrilla. It's a swift, high-impact use of domestic and international criminal law aimed at just incapacitating a single individual soldiers, sending the signal that impunity will not be tolerated and that we will be targeting Israeli soldiers wherever they are. And this is, we use a twofold approach. The first one is targeting what we call the traveling soldiers, and then the dual nationals. When it comes to the traveling soldiers, it's basically when we hear of an Israeli soldiers stepping into a foreign soil, whether on vacation, visiting family, between deployments, we file a complaint in that state. So, and as has been said earlier, universal jurisdiction statutes in many countries, such as Greece, Germany, Belgium, they've given us the legal foothold that we need to file those claims. And so by striking where the perpetrators are the most vulnerable, we create some kind of a choke point that should normally force a rapid response, an investigation, at least an interrogation. And more often, what happens is we see the perpetrator leave the country and at least ending their holiday and going back to Israel. So this is like a legal sprint. We have a few days, 1 to 3 days maximum, to file a complaint, organize, finalize our investigation, draft the factual and legal analysis, gather all the evidence, put it in a complete form, find a lawyer, and then we file. This is an activity that we do regularly, on a monthly basis. I've calculated as part of the public cases, because of course, we also have a lot of cases we don't communicate on. We have, since the creation of the foundation over the year, more than 33 cases that have been filed. And as I said, those are only the public cases. And then the other approach is targeting the dual nationals. And this is more the long-term process. So this is when a soldier holds citizenship from another country. And so we aim to bring the case to that country's court. And in this case, the jurisdiction is not disputed. The political calculus also is different, because the host state has the obligation to investigate and prosecute its own national. And so for those cases, we have time. We have time to conduct in-depth investigation into the individual. We have time to build cases around the entire unit, battalions, brigades, to find information about superiors, victims. And this is what we are currently working on. It's the long-term approach. So far, we have 4 public cases of dual nationals, and there are many, many, many more to come. This is a longer process, a litigation for the foundation. And one part of the work, and Basel discussed it, is how we feed also international criminal efforts. So our most important filings will be sent to international courts like the International Criminal Court or the International Court of Justice, when we consider it's important that those institutions are informed of the crimes. And usually those are big filings with a big amount of investigation put into the submissions. And so each SWIFT filing is a reminder, and this is very important, that the world is watching and that we are ready to act on a daily basis if an Israeli war criminal step foot in a jurisdiction where those crimes can be prosecuted. And this is the message that we want to send. A question that we often ask is, why do we focus on the low-level perpetrators, the rank-and-file soldiers? So the rank-and-file soldiers, the junior commanders, the lowest perpetrators, are the most visible agents of the genocide. And ironically, they also generate the most readily accessible evidence. They're the one who publish on their social media videos, pictures, montage edited with music and laughter and boasting about actions that clearly amount to international crimes. And so by targeting those individuals, what we try to achieve is breaking the wall of the culture of impunity. When a soldier knows that a holiday abroad can lead to an arrest, the calculus of acting in total freedom shifts. And we have seen it. After our filings, there is panic ensues. Israel has issued guidelines for its soldiers for traveling, following our complaints, to guide them in how to behave if they are targeted by our legal actions. Ideally, it would also create a domino effect. So if there is an arrest in one jurisdiction, it could make it more difficult also for soldiers to consider traveling in those countries. And of course, the main objective is to build a foundation for larger cases, because each of those individual cases adds to a growing body of evidence that will later support charges against high-ranking officials, planners, policymakers. So it's the pyramid strategy. You start by establishing the crime base and the direct perpetrators, and then we go up the chain. And this is what we're working on establishing larger and larger files as we go along and collect evidence. And so our most visible work today is the complaints against low-level perpetrator, but it's merely the tip of the iceberg. As I said, we're assembling pieces for larger cases, identifying every participant in specific incident, from foot soldiers to commanding officers and senior political officials. And at the same time, we are mapping the jurisdiction that can hold each of those individuals accountable. And so our offensive litigation is therefore not a piecemeal approach aimed at just a few worst offenders. It's a coordinated global push intended to puncture the wall of impunity surrounding every single Israeli soldier everywhere in the world. I'd like to now talk about strategic litigation just very briefly, because of course, strategic litigation, as I said, is our long-term strategy, and we don't communicate much about it because the cases we are working on are at the moment confidential, but we are working on planting the seeds for lasting change. And in many countries, the universal jurisdiction framework is limited, and limited sometimes due to past actions by organizations like PCHR, who have previously attempted to bring Israelis to justice, leading to a change in the universal jurisdiction framework. And so our strategic work aimed to tackle those barriers heads on, and by challenging the statutory limits and setting precedents as we go, and we aim to influence policy and the law. And the ultimate goal would be to force government to change their policy and legal framework on war crime accountability. And by showing also, by highlighting how those limitations make those countries also complicit and responsible as countries hosting and being safe havens for Israeli war criminals. And we've seen it in the UK just recently with the visit of the president, where the UK hasn't done the president, or at least done any actions in that regard. And so strategic litigation, in opposition to offensive litigation, which is more as a sprint, strategic litigation is the marathon. It requires patience, deep research, and sustained advocacy. But we are working actively on this strategy. And so those strategies, as I said, they work hand in hand. As I said, the offensive litigation creates this evidence flow. We create new documentation cases, and we are building larger cases. And it also allows us to map relevant jurisdictions. We are exploring universal jurisdiction in countries where no one has ever filed a complaint in this basis, and we are trying. And sometimes it's very challenging because the domestic lawyers don't know anything about the legal framework. So we have also to discuss, educate the lawyers and tell them what is the international legal framework, how does it apply to their country, and try to understand also how the legal system domestically works. So there is this work that is done. And then when we are done with all this work, we will be more equipped to file those bigger cases in relevant jurisdictions. And you wanted, I think, part of the work, my speech was also supposed to talk about the challenges. And as I said, the foundation has been functioning for almost a year, and we faced many challenges. And the first one is that despite, as I said, all those cases, not many people have been arrested. I mean, so far, as Hannah said, we had the arrest and interrogation of 2 Israeli soldiers during the festival in Tomorrowland following our complaint. That was a positive step, but they were still released and they still went back to Israel. So this is very, very difficult. There is another case that I've been working on. I've been mapping this soldier. We filed against him in Spain a few days ago, and we had already spotted him in Cyprus. So he's been going on holiday since the beginning of the summer, and he continues, and we continue filing despite this. So we don't stop. But it's true that in many jurisdictions, states do not comply with their obligation to investigate, arrest war criminals. So this is a reality. Maybe in closing, so as I said, we work at the intersection between rapid legal actions and long-term goal of achieving accountability for Palestine at every level of the Israeli society. And so by mixing those both strategies, we are forging a path towards genuine accountability for the crimes committed in Palestine. And as I say, we are just starting now. And I hope that together we'll continue to turn the tide of impunity and into a tide of justice. And that throughout the years we just started, we will bring justice for Palestine. Thank you.
Thanks so much, Natacha, for outlining these different strategies of offense litigation, of strategic litigation, and for providing us with these examples. I would like to now move to the Q&A section of this panel. You are free to drop your questions in the chat, and already thank you to all those who've already put their questions in the chat. And this will be for around 30 minutes. Okay, the first question I would like to ask, I will do it in section of 3, and then I will collect some more questions, and then we'll do it like that. My first question is for Basel, is that following the sanctions, how do you see the prospects, and it's the sanctions against the ICC that I think they're referring to, the prospects for proceedings at the ICC, further arrest warrants, for example, for Smotrich or Ben Gvir, because they say there's no progress at all. And what do you think is the impact on the proceedings at the ICJ on genocide? Then for Shane, the question is that Germany has used universal jurisdiction to prosecute Syrian war criminals and even set up reporting offices for Ukraine. Yet nothing has happened on Israel. And why is the Attorney General acting despite the principle of legality, or isn't acting? And what can international pressure change this? And for Dania, I was wondering like, what challenges you face in the UK in doing these cases, and also what challenges you face with courts understanding the international legal obligations from, like, for example, the proceedings of the ICJ. Basel, would you like to start?
Thank you, Hannah. It was very interesting to listen to all the incredible work that's been done by everyone, the panel, Dania, Shane, and Natacha. I think this is reflective of the important work that's being done to break Israel's wall of impunity. But let me say, with the sanctions, even before the sanctions that have been happened, we've been facing a lot of challenges as PCHR. It has to do with the security of our staff, security or the evidence that's being collected, the non-stop genocide, the living conditions that people are facing on the ground, from starvation to forcible displacement, the evidence that's being constantly destroyed and changed. You're talking about areas that keep on being invaded and destroyed one time and again, graves which had bodies that are being dug up. The Israelis, the occupation forces, they created mass graves, but then they opened them up again and remove the bodies and get the bodies out, and just the chaos, the situation, the chaotic situation that they have managed to create over the 2 years, along with the non-stop genocidal actions, have really made our job much difficult. Of course, we are talking about some of the witnesses that we have taken testimonies from. They have been killed. Our staff, we've lost 3 members of our staff as PCHR: Dania, Noor Abu Noor, Hab Faisal. Maybe they haven't been directly killed as a result of their work. We don't know that yet, but they've been killed along with their families, and it just reflective of the situation that many of the people in Gaza, from the human rights community, from the civil society community, are facing. We have no international journalists coming in. We have no UN Commission of Inquiry coming in, or for example, the ICC prosecutor's office, nothing. So we're talking about 2 years where no one had access to this territory. And every day, the conditions for exposing the crimes, it's getting difficult. We're talking about more than around 250 journalists that have been killed. With regards to the ICC, of course, this creates a problem because, first of all, they're not talking to the people who are on the ground. But let us not forget that there are Palestinians who have managed to get outside of Gaza. They're in Egypt, they're in Turkey. Some of them, they have been hosted by EU states. So it's important that these people are witnesses, these people are victims, and the evidence, it's still there. There's no excuse for anyone to say, well, we are not in touch with the victims in Gaza, we need witnesses, we need etc. No, there are people who are outside and that can be used for all the legal cases. With regards to the ICC, of course, there are now significant challenges. We now seen, I think, around 7 judges now from the ICC sanctioned, 2 deputy prosecutors, the prosecutor himself who's on leave, and of course the 3 organizations and the special rapporteur who were cooperating with the investigations of the ICC. So this makes it very difficult. We saw that the second round that has been imposed on the deputy prosecutors and the judges, they were imposed when there were news, there were media reports that the ICC was planning on issuing arrest warrants for Ben Gvir and Smotrich in relation to on charges of apartheid and settlements. Several days, one day after this or 2 days after this media report got out, we saw that sanctions were imposed on the two deputy prosecutors who are currently in charge of signing off these decisions. So of course there are many challenges facing them, many challenges facing the witnesses. Many people now will be scared, because they don't want to be involved in any kind of trouble with these organizations after the sanctions. They feel that their life is under threat before. And currently it can be under threat even more. We see that Israel is going after flotilla boats, even as far as in Tunisia. We're talking about peaceful activists and drones dropping, they're dropping drones on them. So there's this feeling of insecurity. But I think this is part of what we are going to face in the coming years with the Trump administration, an attack on international justice institutions, an attack on human rights organizations, an attack on the rule of law and international law. So I think we're approaching a very difficult period, but at the same time, we should always stick to our principles. We should stick to, what we are calling for, to justice, for international law, despite the risks. We're as human rights, as a staff of a human rights organization that got sanctioned by the US. I can definitely tell you that there is an impact on that, and not at PCHR level, but I mean anyone would feel not secure now. Our WhatsApps, our signals, our emails, etc., our bank accounts, the existence of the organizations themselves are under grave threat, because effectively this means financial, you're being blocked out not only from the US, in the US territory, but it effectively blocks you out from all the banks, because all the banks are at the end of the day in relationship with the US banks and the US financial system. So we saw yesterday that even the opposition of the Israeli, one of the Israeli parties, he called for dismantling the UN as a whole. We're seeing the denying of the UN visas for Palestinian Authority. So we're approaching very difficult months for those who generally work on the field. But what's certain is that it's better, you're gonna be facing consequences anyway. So it's better that you face the consequences while you're standing on the right side of history, while you're standing on the right of justice, than to be silent and complicit in this unprecedented live stream genocide and against this settler colonial regime.
Thanks so much, Basel. Dania, would you like to go next?
Yeah, sure. I think when we speak about the challenges and operating in the UK as a legal organization, the main one that comes to mind would be the political climate that we are actually working within. And as much as the law is clear cut, usually for lawyers, like you identify a case, you identify the legal criteria for it, and you do the work. Sometimes political considerations do come into effect. And I think this was very evident in the arms case that was brought by Glan Al-Haq, which ICJP supported as well, where the court, this primary reason for siding with the government was that this was a decision that included considerations of high foreign relations and national security policy, and therefore the court did not refused to actually decide on the case, or actually sided with the government that the decision, they didn't actually decide whether the decision to keep supplying F-35 components was legal in itself or not, because they made no determination regarding the lawfulness in the criteria that was set by the government itself for itself. So I think it's when you bring a legal case and then political considerations do come into play, specifically when courts are making decisions. So in that case, we did not see the court ruling whether the UK's decision was lawful when it came to whether Israel was, using these F-35 components and violating IHL, which is in the government's view, these obligations, were not violated by Israel. So I think the political climate is a tricky one. And I think as well, when it comes to politicians being complicit in making decisions as well, that are enabling Israel to continue with its crimes, and also making very little decisions on whether to end that complicity when it comes to either trade or arms, or other either diplomatic relationships, and it doesn't go beyond condemnations and words. So I think it doesn't really implement a lot of pressure. And I think the other challenge as well is overcoming the anti-Palestinian human rights narrative that is in the UK. So it's a very tricky space that we work within, and I think legal organizations have an extra burden of not just doing their legal work, but also being able to overcome this narrative that is set by other organizations that are working against Palestinian human rights. So I think these are the two main things that I would, I think of as challenges. Now, when it comes to how domestic courts interpret international legal decisions, I think one thing that's really important to consider in the UK, that the legal framework we work within is international legal treaties that the UK has acceded to and obliged itself to actually uphold. But really interestingly, the UK did also interpret these obligations into its own domestic laws. So when they signed the Rome Statute, they did adopt a legislation called the International Criminal Court Act. So this is actually a part of the UK domestic obligations at this point, because they have a domestic legislation that speaks about these things. Or in some other instances, the Geneva Conventions Act, which is also a UK legislation, and other principles of universal jurisdiction. So I think when it comes to these kind of obligations, it's very important to remember that they're embedded in UK legislation. And that would be the first point of argument that we would go to, is that these crimes are crimes under UK legislation. And therefore, these are the elements that we believe have been fulfilled by the evidence that we've been gathering, and all the legal work that we've been doing. So I think that would be it.
Thanks, Martijn. Shane, would you like to go next?
Yeah, I might just pick up on a couple of things that were said there. I think from an international criminal law perspective, the International Criminal Court and the whole international criminal justice process takes the perspective that not all crimes are going to be prosecuted. It's just not resourced. States haven't set it up in a way to do that. On the other hand, in domestic criminal justice systems, we expect that every crime that takes place on the territory of that state should be prosecuted. Politicians wouldn't last very long domestically if they didn't deal with domestic crime. But then universal jurisdiction crimes are a little bit in the middle, the perpetrator might be a national of the state or they might be present in the state, but the crime has taken place elsewhere. So there's less political pressure on states to address these crimes, with the result that where they do even have some sort of war crimes division or something like that, they're grossly underfunded, they're grossly unsupported, and politicians don't yet get the pressure to deal with these sorts of offences. Now, dual national, I think, is certainly a place where there's a strong case to raise that sort of political price that states have to act and address these. I mean, there are certainly examples we can see of universal jurisdiction cases, but they in no way match up to the expectation in the drafting of the Geneva Conventions that we don't need an international court. States will do this domestically. They've tended to, with their own soldiers, for example, maybe through a military justice system, but when it comes to those from other nations, they've not demonstrated the same willingness to do so. So the dual national examples, I think Mohammed's question refers to a German court. We had a Guardian article about snipers from the United States and from Germany who were responsible for killings in Gaza. Both of those countries have prosecuted individuals, including non-German and non-United States nationals, domestically for crimes taking place in conflicts like Syria, in Liberia, and others. But it does come down to that political pressure and getting them to do that. I think that's one of the key issues. So ICC statute countries, obviously there's more of a legal basis for them to pursue that, but we still haven't normalized the idea that you should be dealing with all of these crimes that are connected to nationals in your own country. I mean, this is a problem that goes beyond international crimes. I mean, some states have legislation that addresses child sexual abuse even when happening outside of the country. We almost never, or very, very rarely, see these prosecutions. States will say it's difficult to get witnesses, it's difficult to get evidence, it's difficult to pursue these extraterritorial cases. But that's not to say that they shouldn't be pursued. Mohammed also asked that if this individual who had served in the IDF wasn't successfully prosecuted in Germany, would the ICC step in? I don't think so. I don't think they're going to deal with lower level soldiers at the ICC. As Basel said, it's Ben-Gvir and Smotrich. If we get a new prosecutor or if there is a resolution of this issue, if we move past acting prosecutors to have a reinstatement of a prosecutor, then we might see arrest warrants. But again, it'll be at the much higher level. It won't be for lower level individuals. The obligation is on Germany, and the pressure needs to be put on Germany to do that.
Thanks so much, Shane. Okay, I will now go to the second round of questions. Thanks so much for already answering these questions. And also, please continue with putting your questions in the chat. They've been very good so far. So my next question is for Basel, and it's beyond the ICC and state mechanisms, what new paths do you see emergent, also in the Global South, for advocacy, People's Tribunal, or other forms of sanctioning of corporates? And another question for Natacha, which is, does going after like more lower level soldiers risk shifting the attention away from political leaders, commanders, and corporations who profit and plan these systematic violences? And also the question is, why is there such a strong focus on like European courts and engaging there for these legal challenges? And why is it this dominance of Western-led international criminal law? So these are the questions for now. Basel, do you want to start?
Yes, but could you just please repeat the question for?
Of course.
Because I didn't.
So beyond the ICC and the state mechanisms, what new paths do you see? Also in light of like the failing ability or willingness of states to act on this, on the slow approach that the ICC is taking for action. Here they mention advocacy, people's tribunals, and other forms of taking action.
Yeah, there have been many initiatives that have been created to, as a response to the lack of, let's say, the rapid response by justice institutions, by like by courts in Europe, etc. There was the World Citizens Tribunal, I think, in the UK, which PCHR took part in. And there were many there was the Gaza Tribunal, I think, that was also established by Noura Arakat and others. And I think this is important, but even as Palestinian human rights organizations, we have invested a lot over the years of our efforts in order to in Europe, in order to make real change, like especially in Western countries, for their claim to uphold international law and human rights, etc. And we've seen, like, when there's a complete attack, like we are seeing today on international justice by the US, and when there's a genocide happening, and when we have, and it couldn't be clearer with the ICJ provisional measures and the decision that was issued as far back as January 2024, and still and despite all the evidence and almost all the human rights organizations like Amnesty, Human Rights Watch, let's say even Israeli organizations like B'Tselem, all agreeing and having a consensus that what's happening in Gaza is basically a genocide, although they differ on which genocidal acts, etc., have been happening. But still, when we have this consensus and we've agreed, and we still don't have much action by these states on the ground, it's really disappointing, and it sends us as Palestinian human rights organizations as that's something that we have maybe neglected over the past years, is the engagement with the global South countries. We've seen really when it came to the genocide in Gaza, and we've seen who has taken action to look at to stand with the Palestinians. It was South Africa that decided to initiate this case despite all the pressure that was imposed on it. They're the ones who stood up and decided to fight for justice and for international law. And even when we look at the referrals that have been made regarding the situation in Palestine, many of those referrals have been made by the global South countries. So I agree with the message that has been there, that we've invested a lot in those countries, but unfortunately we need to also invest in the global South countries and try to make those countries and even with the Hague working group that was established, and when it was convened in Colombia, these initiatives, they have been all in the global South. So it's important from our side as well, as Palestinian human rights organization, to engage with the global South.
Thanks so much, Bas, for sharing. Sorry, for sharing that example. Natacha, could you go ahead next?
Thank you very much. I think so. The first question was about targeting low-level perpetrators and how this would deflect from the ICC cases. It's correct, if I understood the question correctly. I think we shouldn't see looking at low-level perpetrators, high-level commanders, political officials as separate. They're all part of the same genocidal policy, and they must be targeted. Of course, considering their respective involvement, and building a case against a high senior political or military official takes time. And the genocide is still ongoing, so we don't want to rush. We want to take our time to build strong cases. This is why maybe the most visible parts of the work that is currently being conducted is on low-level perpetrators, but it doesn't mean that there is not many higher cases that are being brought. One example that I can give you is a few weeks ago, before the summer, we filed a submission to the International Criminal Court regarding the liability of Yehuda Havar, who was responsible for the Netzarim corridor responsible for so many deaths in the corridor. So you see, there is still efforts that are being done, but as I said, it's only the beginning, and the cases are being prepared. And I don't think it would deflect. On the contrary, the ICC is focused on, as it was said, on high-level perpetrators. It's all they can handle anyway. And they might issue new arrest warrants, hopefully. So we'll see what it would lead. And this is our responsibility as civil societies, our people who can see those soldiers every day, to bring them to justice, because no one else would do it. So yeah, that's to answer the question. Regarding the jurisdiction, why the EU? We have filed, everywhere, in Thailand, in Peru, we have filed in many other jurisdictions, in Brazil, in the US too. Why the EU is basically because this is where most Israeli soldiers are going on holiday at the moment. But we have other cases that we are planning to file in other jurisdictions that are non-EU. So it's basically, and of course, why the EU also is because the universal jurisdiction framework in those countries is the one that is the most exploited, the most developed, and the most easily exploitable. So to answer the question. I just wanted to address, I saw a few questions. One comment on the journalists. I just wanted to clarify there is someone who was talking about the CPJ, the Committee on the Protection of Journalists. I think there is a misunderstanding just regarding their data. They've documented only 21 cases, but they argue, their claim is that there's more than 197 journalists killed. But themselves, they have only documented 21 journalists. They're not claiming only 21 journalists were killed. So I just wanted to clarify this. Same of the Gaza Humanitarian Foundation, the GHF, the cases are coming. So same. Many people are working on those cases. There are dual nationals involved and so on. So this is coming also. So yeah, and also on the US, similarly, the situation at the moment is a bit difficult with the current sanctions, but of course the US, and if there are any lawyers or anyone who is willing to explore universal jurisdiction or extraterritorial jurisdiction in the country, they're more than willing to, welcome to contact us to work on that.
Thanks so much. Since we're ending the end of this important conversation, I would like to give all the speakers a few more minutes to take the floor and to give their final remarks. So Shane, I would like to start with you. If you have any questions that you still feel are unanswered, or any words you would like to share, please go ahead.
Yeah, thanks, Hannah. Yeah, so it's been a really important and valuable discussion. There's quite a few coming up in the questions, and it's not possible to get to everything, but just a couple of things to mention. So there was a question as why the sort of Western states orientation of these cases, and I think Natacha has answered that quite well in terms of individuals, but also for the corporate accountability side, not just in Palestine, but in many of the cases that have been taken in the UK as well, such as the BP type case, but other similar cases. These are the home states of many of the world's biggest corporations. This is where they are based, and this is where their wealth is. So using the domestic courts of those countries is a way to try and get justice for crimes or offences or human rights violations that may have happened elsewhere. So we do see litigation in the United States, less so now with the Alien Tort Statute being circumscribed, but with Canada, the United Kingdom, and numerous European states as well. But that being said, there shouldn't be any hesitation to use other jurisdictions where feasible. If you take, for example, Shell's activities in Nigeria, the Nigerian courts were effectively shut down in terms of access. So that's why there was cases pursued in the UK and in the Netherlands. In India as well, where we had the big explosion about 30 or 40 years ago, the agreement between the company and the Indian state meant that victims could no longer pursue cases in Indian courts, which is why they turned to the United States as well. So there's various reasons feeding into that. There was a question as well about the ICC as well and the International Court of Justice. And I think Basel touched on this as how the Palestine case is sort of reclaiming international law. So we have this big paradox where we're all at the one hand, we're saying international law and international criminal justice is failing the Palestinians as it is significantly. Yet the ICC and the ICJ are being attacked like never before because of these cases, particularly the ICC. So on the one hand, we're disappointed with what it's doing, but on the other hand, the British, the Americans, and the Israelis, of course, are targeting the court, targeting its judges, targeting prosecutors because they fear the potential that it has. So I think that's important to bear in mind. It remains a battleground as well, and Palestine is really the test case for international justice. But there is no silver bullet. We have to pursue all the various avenues of accountability that have been discussed by all the colleagues on the panel today. I think that certainly needs to be borne in mind. And some of the questions point to many things that we haven't talked about. Civil litigation and other forms of accountability, those are there, and there are other ways as well that need to be taken into consideration. But again, thank you for the invitation to participate.
Thanks so much. Basel, would you like to go next?
Yes, thank you, Anne. I would also like to thank very much Shane for broadening, our perspective to pursuing the accountability for Palestine, and that it's not only about international criminal law, it's not about only the ICC and about the ICJ, but it's important to look at also, as Dania has mentioned, with regards to complicit to the companies that are driving this genocide. It's not only states, but there are companies who are profiting off from this genocide, and it's important to pursue all possible avenues and to broaden our perspective and not to only focus on the ICC, and they are very important, especially the case at the ICJ with the South Africa. I think it will take a couple of years, and hopefully, I think this, with all the evidence and all the consensus of the major of the human rights community around the genocide that's happening in Gaza. I hope that there will be a finding on this genocide, and then it will open the scope. At the same time, yes, we are failing in ending this genocide, despite everything that's happening, despite all these efforts we have spoken about from, like just these 5 organizations who are participating in this panel. Still, but at the same time, we must remind ourselves that we are facing powerful forces, well-resourced, that have power, that can be very extremely harmful. But at the same time, I think if it wasn't for the work that everyone is doing, yes, we might have been sanctioned. But this is not only a threat to us as Palestinian human rights organizations. This is a message for everyone who's involved in the accountability work for exposing Israeli violations, in trying to hold Israeli accountable. That was a message that you are next if you don't stop pursuing Israel for its genocide in Gaza, because the evidence is clear, the law is clear. The people on the ground in many European countries and across the globe are standing with the Palestinian cause. I think, just one last thing, I want to reiterate that we should also expand our scope, as Shane has mentioned, to explore all the avenues that are possible, whether it's corporate, civil litigation, international criminal courts, international court of justice. We have to keep the pressure. And I think I believe that at the end of the day, despite all the attacks that we are facing, this will not be a forever situation. Things change over time. Things don't change in a second. This is a long battle with really powerful forces, but we must remind ourselves that it's a cause that's worth fighting for. It's been happening 2 years. It never happened 2 years. People are being slaughtered in every single minute. They are being annihilated. they are being ethnic cleansed, and still the project is going. We have to keep the pressure no matter what. And I want to thank Law at the end, Law for Palestine, for organizing this discussion and for inviting this great panelists to hear from them about their different work. Although we know about Hind Rajab and the great, because we have been partnering on several things, but I want to thank you very much for being here, and yeah, keep up the fight.
Thanks so much, Basel, for these very kind words. Dania, would you like to go next?
Yeah, thank you. I think I'm going to keep it short. I can't echo enough what both Shane and Basel have said, and I think it was brilliant to hear what everyone else is working on. I think we're truly at an unprecedented point, not just in the atrocities that are being committed, but also in the legal space, with so many test cases that will pave the way for us to see what happens, and hopefully it will pave the way for accountability. I think it's really difficult to answer all the questions that were received, but I saw some questions regarding some politicians and, holding those to account. And I do think this is the moment to have everyone fear and feel the heat of what's happening. And it is the moment to hold everyone to account, regardless of their position. So if it's, foot soldiers, senior people in the military chain of command, politicians, corporations, even supermarkets that are, putting on their shelves settlement products that are, illegal, and their theft and pillage of natural resources. And I do think there are some test cases that we will see how they unfold in the future. We at ICJP have submitted a complaint to SO15 back in January 2024 against 4 UK ministers from the Conservative government regarding their complicity. We're still waiting to hear back from the SO15, which is the War Crimes Unit at the Scotland Yard. There's also another test case that is happening in Canada that was brought by a coalition of Canadian legal advocates, including ICJP Canada. And it's against the government for their failure to act to prevent genocide in a violation of its legal obligations under the Genocide Convention, and on behalf of the plaintiffs and under the plaintiffs' rights under the Canadian Charter of Rights and Freedoms. So I do think it's a very critical point. And on that note, I do have to say, I'm a true believer that if the law is strong enough to protect the rights of Palestinians, it will be strong enough to protect the rights of anyone else. And I think that's the test that we're at the moment. And yeah, thank you very much for having this panel, and thank you for all the brilliant panelists.
Thanks so much, Dania. Natacha, would you like to also have final words or address any questions that haven't been addressed yet?
Thank you very much. I'll just be brief. I just want to share the joy in seeing in the comments all the enthusiasm about wanting to pursue different legal strategies, different perpetrators, all the ideas that came from the chat. And I hope all of you will keep this energy to bring them to life, either through the organization that were present in this panel or through your own initiatives, because what we have seen in the last 2 years is that individual lawyers, individual legal professionals, can make a difference, and that by organizing yourself in your own country, you can bring a case or liaise with people with expertise. So do not stop yourself from doing what you think is right. So that's what I wanted to say. And thank you very much, Law for Palestine, for the invitation. And I hope to see you all in better circumstances. Thank you.
Thanks so much. Yes, then now it's up to me to thank everyone. And I've really learned a lot during this session. So thank you so much for all your very great contributions. And also, I was just really touched by Basel's word that in this time that of grave attacks on courts, on the attacks of human rights organizations, but also during the ongoing genocide, that if like you and these organizations are not giving up. We should not give up in our work and join Natacha in the work and take these actions. So that's been a really inspiring session for me. I would really like to thank on behalf of the organizers, ICJP, Al-Haq and PCHR, and of course also Love Palestine, the speakers for sharing your insights, and also thank the participants for joining us today, for sharing your questions in the chat and for engaging. And I hope that this engaging will also continue after this session. And of course, the Jurists for Palestine Forum. I also like to thank Nuran for organizing this and the interpreters who've done a great job interpreting our English to Arabic, Noor and Amani. So thanks so much for making this discussion accessible. And a record of this panel will be accessible on YouTube, so you're able to share it, to watch it back. And please also share this message with others, because I think a lot of valuable insights came from this session. And that brings this session to a close. Thank you again. And hopefully we're able to see you at the next conversation in other forums.